Good afternoon. I want to welcome all of you to today's session on the recent CFPB consent order with Nissan Motor Acceptance Corporation and its implications to repossession activity. My name is Michael Levison, and I'm the CEO of Resolvion. For those of you that are not familiar with us, we're one of the leading repossession management and skip tracing companies in the country. We offer a wide range of services, everything from forwarding to skip tracing, LPR management, impound management, remarketing, and even heavy equipment recovery. So that's going to be the extent of today's commercial on Resolvion. The real reason why we're here is today's webinar is part of our Insight series. We've always felt that disseminating information and sharing best practices was part of our role in the industry. And accordingly, we put out a lot of white papers, sponsor webinars like this, do industry surveys to that end. I'm joined today by Bill Denius. Bill is a partner in the law firm of Killgore Pearlman. Bill's got over 25 years of experience in advising creditors on legal and regulatory matters, including litigation relating to those issues. Bill's also active on the AFSA Legal and Compliance Committee, studies CFPB issues very carefully, and has some really interesting insights to share with us today. In the background, I'm also joined by Thi Chang. She's our marketing director, and Thi will be assisting with your questions. We've got a couple of polls that we've sprinkled in. And if you have any issues, just send her a message and she'll respond. You know, the recent consent order does cover a lot of ground, but we're going to focus on really two provisions that address and relate specifically to repossession activity. One covers what the CFPB refers to as wrongful repossessions, and the other relates to the charging of fees relating to the handling of personal property. So Bill and I are going to focus our comments on the implications of the specific requirements around those two issues. We're not prepared or really able to comment on any of Nissan's practices that led to these requirements. We're not familiar with those practices, and even if we were, it really wouldn't be appropriate to comment. Okay, let's move forward. Today's agenda, we're going to focus on the consent order and its provisions around the two issues that I mentioned, wrongful repossession and personal property. We'll also discuss compliance issues and compliance strategies and solutions around both of those topics, and then hopefully also have plenty of time for Q&A. And with that, I'm going to turn it over to Bill to start the discussion around the wrongful repossession topic.
All right, and good afternoon, everybody. So yeah, we're going to start off by talking about the wrongful repossession portions of the consent order. The issues addressed in the consent order, we have the screenshot up here now. It talks about in relevant part, the definition of a wrongful repossession, then goes over exceptions to wrongful repossessions, and also goes over required affirmative actions. And we're going to go over those three things now. So it defines a wrongful repossession as, and this is an abbreviated version, but it's where the creditor repossesses the vehicle even though one of several things has occurred. The first being where the customer has agreed to make a payment on an outstanding date. The second scenario is where the creditor repossessed, where the creditor has agreed to an extension agreement to bring the account current, and the customer is not delinquent under that agreement. The third scenario is where the creditor repossesses even though the customer has brought the account current. The fourth scenario is where the creditor repossesses even though the creditor agreed to cancel or postpone the repossession. And then the fifth scenario is similar to the third scenario. It's where the customer has made a payment which under the creditor's practices, policies, and procedures was sufficient to stop the repossession. So to boil these 5 points down, really into one or 2 points. A wrongful repossession occurs where the creditor basically agreed not to repossess, or 2, where the customer paid up and brought the account current. Now, I did mention there are 3 exceptions. They're kind of convoluted when you read them at first, upon first reading in the consent order, but they're really quite simple when you boil them down. And the first and the one on the bottom here all relate to a repossession occurring within 6 hours after certain circumstances. So as you can see, and we've broken it down here, there's an exception for repossessions that occur less than 6 business hours after either the customer notified the creditor of a payment bringing the account current or sufficient to stop the repossession, or 2, the creditor has accepted an agreement to cancel or postpone the repossession. That's pretty straightforward. Also falling within the 6 business hours exception is at the bottom of the page there. And that's where the customer has made a payment via means other than the online payment portal, which was at issue in the relevant consent order. That may not be relevant to other folks, but and it's within 6 business hours after the payment posted to the customer's account. And notably, that exception only applies where the creditor's records do not show notification of payment. And then lastly, I'll go over the one in the middle here. And this also applies when the creditor's records don't show a notification of payment. And it provides for an exception or a safe harbor for a repossession less than 1 business day after the customer makes a payment via the online payment portal to bring the account current or something that would be sufficient to stop the repossession. So the second and third exceptions do appear to be a bit more fact specific. The first one is a little more general. I can explain those a little further unless you had anything to add in on that, Mike, at this point.
Nothing really to add in, but I'm curious as to your thoughts about the sort of the second and third points. Do you think they're in there because they relate specifically to NEMAC systems and perhaps some limitations or ways in which those systems operate that required this kind of clarification?
I do. I mean, they do seem kind of, strange to the, normal layperson, and they definitely don't, upon a reading of them, seem to apply universally to all auto finance companies. They do appear to be fact specific. It's interesting that the second and third ones only apply, again, as I pointed out, only where their creditors' records don't show a notification of payment. And then they distinguish between the payment via the online payment portal and a payment not via the portal. So yeah, I think that there's something fact specific going on there.
Yeah, the first item I think addresses what is really a universal challenge in the industry, and that's the communication between the various parties involved and the speed of that communication. That's a challenge for all lenders, but these other 2 seem to relate to something specific within the NEMAC processes, but not sure.
Yeah, and I would add that I think they all sort of make sense from the perspective that there should be some, and I'm sure you'll go into this a little bit more here shortly, but they all do sort of universally make sense from the perspective that there should be some reasonable period of time for the creditor to provide notification from the customer down the proper channels and to the truck level, as I believe you've used that term in the past. So moving on to the next slide here, the consent order also goes over affirmative actions that are required, and these are notable because this is what the CFPB has required the creditor to do as a result of these wrongful repossessions that we've gone over, and what to do to what they're required to do to sort of correct and ameliorate the situation. So number 1 is review their repossession assignment and cancellation process and adopt reasonable policies and procedures to avoid wrongful repossessions. Number two, to review their process for monitoring and addressing system error messages relating to canceling or holding repossessions, and to develop and implement necessary changes. The fact that they're pointing out system error messages, I just found that a bit interesting. And again, something that lends to a more fact-specific situation. And then moving back to more generalities, they're required to track and maintain records on all future wrongful repossessions, conduct a quarterly review of the wrongful repossessions to identify patterns and practices that need to be addressed to stop that. And then finally, to provide consumers with remediation for future wrongful repossessions to be paid no later than 7 business days of notification of the wrongful repossession. And this includes things like repossession-related fees, correcting the consumer report, reimbursement for loss of use of the vehicle. And that's it for the affirmative actions there.
Actually, I'm going to go back up. So, Bill, do you think that, and I'm sure that a lot of the creditors on the call will be interested in this, that when the CFPB enters into an agreement like this, which is very, obviously it's institution specific, and makes it public, does this become essentially a de facto expectation that they're likely to apply across other examinations in the future?
Well, yes and no. I think the answer is probably more of a no than a yes. But just to clarify what we're dealing with here, it's a consent order, and that's an agreement between the CFPB and a particular entity. In this case, the particular entity which is the subject of this consent order, which the CFPB characterizes as basically a negotiated settlement. It's negotiated, it's an agreement. The consent order describes the Bureau's findings and conclusions concerning violations by that entity. Interestingly enough, even in this very consent order, as is typical maybe with other consent orders as well, there is no admission to the findings and conclusions. It's a resolution, an agreed settlement. And a consent order is also obviously it's not a law. It's not enacted by Congress. It's not, passed by a state legislature. It's not signed off by the President of the United States. And because they are particular to, or specific to a particular entity, they're not binding on other parties. As the CFPB points out itself with regards to like supervisory findings, they say in their cover sheet on those that a conclusion that a legal violation exists based on specific facts may not lead to the same conclusion under different facts. So with all that said, the CFPB has characterized consent orders as public mechanisms to deter future violations. So I think at the end of the day, they provide guideposts for others. And although they're not de facto requirements for everybody going forward, entities should pay careful attention to them, and especially the things in them that are not fact specific.
Makes sense. Okay, let's move on. Actually, let's do a poll. So we're gonna, and this sort of relates to the issue that we were just talking about. But Thea, if you'll display our first poll question. So the question is, does your institution have a defined process for monitoring and mitigating wrongful repossessions? So it looks like 61% do and 39% don't. And to your point earlier, Bill, that it's not necessarily an across-the-board policy. My guess is that this will be something that this will be the lens that the CFPB looks through when they look at wrongful repossession activity at other lenders that they'll examine in the future.
Right.
So, if you don't have a policy around these issues and that addresses the issues that were raised in this consent order, the requirements that were mandated in the consent order, probably a good idea to put one in place.
Definitely.
So, now that we understand what the, the CFPB is looking at it and how they're defining it, let's talk about how to mitigate it. Based on our experience, there's two primary causes for these wrongful repossessions. One, and frankly, this accounts for about 80% of the wrongful repossessions that we see, is lender error, where the lender did not have the legal right to repossess the collateral. Could have been a lien loss or some other issue, but there was no legal right at that time to repossess. And the other, which sort of is a variation of the same point, the lender did not properly communicate the status change of the case. In other words, it was out for repossession. Something transpired where the repossession order was to be canceled, but it wasn't communicated to the agent or to the forwarder. And as I said, about 80% of what we see falls into that category. And then the remainder falls into what I would call as, or term as, communication delays in the supply chain. You know, when a lender wants to cancel or put a repossession order on hold, that information has got to go from the lender to perhaps a forwarder, to the repossession agency, to the driver in the field who may have that customer's address on his run list that day. And you know, there are plenty of opportunities for there to be breakdown or delays in that process. So how do you mitigate that? One, obviously at the lender level, you just got to tighten up any gaps in current procedures. We've seen in a number of institutions where the sort of the responsibility for alerting the repossession partners of the change in status is manual. It's spread out across multiple people. All that really needs to be tightened up to avoid scrutiny around this in your audits. And then the other aspect of it is the other, mitigation step is to really have end-to-end integration with your partners, and to pick partners that can support that, because there is technology out there today that allows the lender to utilize, one of a number of repossession management platforms that are available. Those platforms are integrated with forwarder systems that are then integrated with the systems that repossession agents are using. Many repossession agencies use mobile technology that connects their offices and their systems to the drivers in the field. And so, a big step in closing in mitigating the risk around communication delays is to make sure you pick partners that have addressed that and have the technology in place to address that. Because without that, I think it's going to be difficult to meet their expectations, the CFPB expectations. This would be a good place to stop and take any questions. I see that we had one question that I think was maybe submitted in advance of the webinar, and that is it legal in the state of California to require a fee for removal and storage of personal items if they don't redeem the collateral? I'm not exactly sure on the answer to that, but I believe that the answer is yes, it is allowable, but the state of California has specific rules, and we'll talk about this a little bit more in the personal property section, but there are specific rules around what can be charged and how much can be charged. I believe in California it's like a per bag fee. See if we have another question here. Is it enough to inform the member that the hold or close of the repo goes through these steps and to secure the vehicle for the next 24 hours? I think that, I think the question essentially is if you warn the customer or the member that, hey, your car has been out for repo and it may take a while for us to get it communicated to everybody that we need to communicate it to. So we're just advising you to keep your car in your garage or whatever for the next 24 hours. Is that enough, Bill, to avoid criticism on the issue?
Could you repeat that question?
Yeah. So essentially, the question is, if I, as a lender, agree to close a repossession assignment because my customer just made a payment to me, can I just tell the customer, look, it's going to take us a while to communicate this, or it could take us a while to communicate this down the line to the various parties involved, so you need to keep your car off the streets for the next 24 hours. Is that enough, that type of sort of warning and instruction, enough to satisfy the CFPB that the customer's being treated properly?
I think obviously the better thing to do is just, I think that's a little bit suspect maybe. I think the better thing to do would be to just have the proper channels, practices, policies, procedures in place so that you don't have to be, telling your customer to basically, from the way I'm understanding the question, is telling your customer to, keep the vehicle in a covered place so that, the agreement can be honored. It'd be much better to, I don't know if that would satisfy the CFPB based on my reading of the order.
Yeah, I mean, it seems that, and again, they may not apply this same definition to other institutions, but it seems like the CFPB has basically said, okay, we understand there's delays in communication. You got 6 hours. You got to figure it out so that those delays do not exceed 6 hours. And so
exactly.
This question seems to suggest, is it okay to stretch that to 24 if you give them proper instruction? And my guess is that they probably would not see it that way, but.
I agree with you.
Now we'll move on to the topic of personal property fees that were and how that was addressed within the consent order. Bill, back to you.
Yes. So this is the other part of the consent order that we're going to cover today with regards to the portions of the consent order that address repossessions. So this is the part about personal property fees, and there is a prohibition against direct charges set forth in the consent order, and it prohibits repo agents through contract or otherwise from charging personal property fees to consumers directly, and I emphasize that word directly because it's there and it kind of pops out, and demanding fees as a condition of returning the personal property. So, stated again a little quicker, it prohibits repossession agents from charging personal property fees to consumers directly and demanding those fees as a condition of returning the personal property. I wanted to point out that the CFPB in its consent order pointed out that these items can include things such as children's car seats, college textbooks, prescription glasses, just as an example of some things that they threw in the consent order. And those might have a little more color in a minute when I go over one of the later slides as to what the CFPB is kind of getting at there. But as I pointed out initially, the prohibition is against charging the fees to the consumers directly. So by virtue of that, and there's no mention of the propriety or impropriety of otherwise charging the fees indirectly. And it's notable that charging personal property fees is actually, as we've already somewhat discussed a little bit here today, it's allowed under most state laws. And as we'll see in a minute, the CFPB actually acknowledges this. But this prohibition essentially follows and implements previous guidance on this issue, because the consent order does not provide a lot of color for this particular prohibition. So moving on to the next slide real quick, and you'll see what I'm talking about. In the CFPB's supervisory highlights from fall of 2016, there were 3 quotes that jumped out at me as they sort of relate to this later consent order. The first is where they said that borrowers often have personal property and belongings and vehicles that are repossessed. These items often are not merely incidental, but can be of substantial emotional attachment or practical importance to borrowers, which are not appropriate matters for the creditor to decide for itself. And then secondly, examiners observe circumstances in which this tactic of leveraging personal situations for collection purposes was extreme, including the retention of tools essential to the consumer's livelihood and retention of personal possessions of negligible market value, but of substantial emotional attachment or practical importance for the consumer. So that brings me back to the things that the CFPB was pointing out in the consent order, like children's car seats, textbooks, prescription glasses. And then finally, and I find this point probably more interesting than all of the others, even when the consumer agreements and state law may have supported the lawfulness of charging the fee, the examiners concluded that there were no circumstances in which it was lawful to refuse to return property until after the fee was paid, instead of simply adding the fee to the borrower's balance, as companies do with other repo fees. So what the CFPB has said here itself in the past is that even though the consumer agreement may allow for it, even though state laws may allow for it, this is not an appropriate matter for the creditor to decide. And there's no circumstance where you can refuse to return property in exchange for a fee, period.
Yeah, to me, this is important because I think it adds credence to the view that the language in the recent consent order, where it prohibits this direct charge, this direct transaction, that it really is intended to operationalize this prior guidance, that it could never, the payment of a fee could never be used to withhold the return of somebody's personal property. And, if you think about it, without a provision like this, without prohibiting a direct transaction between the two, it's sort of hard to enforce a provision like that or a requirement like that. So we believe that that's really the intent here, is to put some teeth into the guidance that they previously provided on this issue.
Right, and then I can summarize this by going to the next slide. Yeah, so what do we make of all this? As we've said, it's clear that demanding fees as a condition of returning personal property is clearly prohibited by the CFPB. The consent order also emphasizes the prohibition, as we mentioned, from charging personal property fees directly to consumers, but there's no mention of the propriety of otherwise charging fees, including indirect charges. And then finally, as was pointed out at the end of the bottom of the last slide, the CFPB itself has acknowledged the propriety, in prior supervisory guidance at least, of simply adding the fee to the borrower's balance, as companies do with other repossession fees. So they're not saying that the fee, charging such a fee is wholly improper in and of itself. It's the charging the fee directly to the consumer and then using that as leverage to persuade the consumer, or to attempt to persuade the consumer to pay. That's what's prohibited. And that ends that slide. Okay.
Okay, let's do another quick poll. Does your institution currently allow a financial transaction to occur between the repossession agent and the customer? Basically, allowing the ability for the customer to, or the agent to charge the customer directly. Oh, pretty close to a split. 52% say yes, 48% say no. Again, every one of these consent orders is specific, institution specific, but this strikes me as an issue that they're going to expect. and a policy that they're going to expect all institutions under their purview to follow. So if you're allowing such a transaction now, you may want to reconsider it. So now that we've addressed the sort of the mechanics of the issue, I did want to give you a little bit of an understanding of the types of expenses that are involved in handling personal property, because I think that it may be easy for some lenders to to use the consent order as an opportunity to just sort of wash their hands of it, but doing that's not really fair to your agent partners, and probably is not in your best interest long term. But and the reason why is that there are real costs in handling personal property. There's storage space and materials that are required. An agent has to rent or acquire more space because of this issue than they would otherwise. There's personnel that have to not only handle the removal and the cataloging and storage of the property, but also personnel required to interface with the customers to redeem it. Oftentimes there's hazardous material involved that requires special handling. And not every situation where there's personal property involved was a jacket in the back seat. Some of these cars are just filled with trash, with items, and it can take hours to clean them out. Sometimes weapons and contraband are found. That requires special handling. COVID has actually impacted the issue. As you would expect, PPE is now required. It takes longer to clean a car out, to change PPE. These are all real issues. Obviously, the whole issue of insurance while those items are on the lot. Damage claims, missing property claims are not uncommon. So they're real cost on the agent side. Your forwarder partners also have some cost in this issue as well, especially under the new guidance, because basically the transaction is going to have to flow from the agent to the forwarder back to the lender, and that creates two separate billing transactions that have to be administered, one from the agent to the forwarder and one from the forwarder back to the lender. So for the lenders that have already addressed this issue, and as you saw in the poll, quite a few have. It's sort of all over the board in terms of what we've seen, but generally it runs between $40 and $75 that is being allowed to be paid for the cost and recovery of the cost involved in handling personal property. Somewhere in that range. So that leaves the issue of how are these costs to be paid, because we've already established that it's no longer allowed to simply have the agent collect from the consumer. So that really leaves in our minds, three basic options. One, lender just takes the attitude, sorry, no fees are going to be allowed at all, direct or indirect. We do not advise that approach. Very few lenders have taken that stance on it, and those that have, we've seen some adverse impact. The better agents just will no longer accept business from unless they're going to be properly compensated for legitimate services they provide. And so I don't think that benefits anybody in the long term. Another approach would be to increase the fee on all repossessions to address this. And I'm going to come back and talk about this in a little bit more detail. A third approach would be to define what the allowable fee is and have that billed back to the lender. So let me talk about each of these in a little bit more detail, because we're seeing lenders, different lenders choose different paths. But on the option of increasing the fee across all repossessions, that would be all repossessions, whether there's personal property involved or not. This approach, in our view, is the easiest to administer for all the parties involved. It may be actually cleaner in a deficiency balance pursuit as well, because it's all part of the, it's just all part of the repossession fee that was posted, as opposed to additional fees that were added post repossession. But to do this properly and for it to be fair to everybody, you have to assume a utilization rate, because again, not all repossessions involve personal property handling. So to add a full charge for that on every repossession wouldn't be fair to the lender either. So an example of what I'm talking about here, let's say that the lender was comfortable that there was sort of an implicit allowable fee of $60 for handling personal property. We at Resolvion went back and looked at our data. 23.5% of all of our repossessions involve personal property handling. So if the approach was simply to increase the fee on every repossession, you take that $60, multiply it by 23.5%. That's $14 per repossession that would be added. And as I said, that's pretty clean. It doesn't create additional billing and administrative fees and processes that have to be managed. The alternative is the bill back to the lender, where the lender decides what a reasonable and allowable fee is when personal property handling is involved, and when it's involved, the agent is billing it back, whether it gets billed back through a forwarder or billed back directly to the lender. That'll be lender specific based on how they manage their repossession process. And then ultimately, it's added to the presumably it's added to the customer's account. Certainly doable. We have a number of clients and lenders that handle it that way. It is administratively more complicated and therefore expensive. Any questions?
Sure. So we have one question from Mayra R. As a lender, if my repo agent charges directly, are we liable?
And the answer to that is yes. And that's what happened in this consent order. The repossession agent is an agent of the lender or the creditor, so creditor ended up being on the hook in part. Unless you had anything else to add there, Mike?
Well, just a clarification question for you, Bill. So again, this consent order is very specific between CFPB and Nissan, and clearly, if Nissan did not follow that requirement, there would be consequences. But for an institution that hasn't been audited or is not under audit, and I assume that when that audit occurred, the CFPB would not necessarily have an expectation that you should have been doing it this way, because we provided this guidance in a prior consent order. But I'm not sure. I mean, it's a legal question, but it sort of goes back to the point I asked earlier. Does this de facto mean that it applies to everybody going forward?
And no, it's just these are the quote unquote rules to be gleaned from these consent orders amongst other parties. So that's basically what it is at the end of the day. But it's all about risk. What sort of risk does the company want to take? To go around and ignoring what other people have been busted for lack of a better term, and to do that knowingly, that's a risk. So, and especially when it's something that's not fact specific. So, when there's certain, for lack of a better term, universal or black and white rules to be gleaned from a consent order, which is somewhat rare, but some of the things in this consent order approach that.
Understood. Any other questions, Steve?
Yep, so we've got a couple of questions here. The next one is from Daniel P. And his question is, why not just add the fee to the total repo cost to avoid a class action lawsuit, which will likely be the next step in this?
Sounds like a loaded question. Listen, as I said in my comments on that topic, our preference and our recommendation is to simply add it to the repossession fee. It's cleaner, simpler, perhaps remove some of these potential other legal challenges down the road. So preferable in our view, but there are other options. Next question.
So the next question is from Ben A. Are involuntary repos being done in California?
Well, I don't know if that's a question relating to the consent order, but certainly yes. The answer is yes. We are certainly repossessing in California right now.
All right, and the next question comes from Mike K. His question is, he's got a different interpretation of the personal property ruling. There's nothing wrong with the agent collecting the fee from the customer. The issue is with the agent holding the property until paid, leaving two options: agent responsible for billing customer and collecting, which is not ideal, or agent can bill back to the lender only if the customer declines to pay direct. What are your thoughts on this?
I'm going to turn that one to you, Bill.
Well, I'm just looking back at the particular language here.
Yeah, I thought the language was pretty specific.
Yeah. I mean, the specific language is respondent must prohibit its repossession agents through contract or otherwise from charging personal property fees to its consumers directly. And it uses the word "and," demanding fees as a condition of returning personal property. So, the way I've read that is that, it is a prohibition against charging the personal property fees directly to the from the agent to the consumer, and then in turn and relatedly demanding the fees as a condition of returning the personal property. I don't know if you had any further consideration of that, Mike, yourself, based on a rereading of it, but I still sort of have the same general impression. I also having trouble seeing the question itself, so I'm kind of missing that last part that talked about two options.
Yeah, I would agree with you. It would seem that if the issue was really around not holding personal property hostage for a fee, that they would not have needed to specifically state that there's not to be a fee charged directly. And then when you combine that with the guidance that they gave previously about the ability to simply add the fees to the customer's account, the two seem to sort of tie together, and that they,
right.
That they try to, as I said earlier, put teeth into that guidance by prohibiting the fee directly. Thea, do we have any other questions?
We do. So this next question comes from Danny R. Does applying a higher fee across the board when some customers may not need personal property handling not create a potential UDAAP violation for the inclusivity of charges that are not actually needed for certain accounts?
So, and Bill, this may be a legal question, but you know, in this approach of dealing with it by simply increasing the repossession fee across the board on all repossessions, some of those repossessions actually had personal property involved and some did not. Does that create some sort of exposure that customers that had repossessions without personal property involved somehow subsidized those that did? What are your thoughts? And I'll share some views afterwards.
I mean, I follow the question there. I just, you know, my gut is that, you know, it doesn't strike me as something that would be unfair or deceptive. But again, I guess you got to be careful about how you go about increasing that fee and justifying it. What are your thoughts, Mike?
Well, I agree. I don't think it's unfair or deceptive, but you know, the reality is that the work involved and therefore the cost involved in every repossession varies somewhat. You know, I had to drive 5 miles to get the car versus 55 miles. So there's lots of factors that affect cost, and so, you know, coming up with a fee that sort of averages those costs across all situations, which is essentially what we're talking about with regard to this personal property issue, does not seem unreasonable to me. And I would also say it's not very material either, because you're talking about you know, in the neighborhood of $15 per repossession. So maybe some theoretical exposure there, but it would seem to be very limited in my view. Anything else?
All right, so the next question comes from Caroline R. Our repo vendor is increasing our involuntary repo fee by $200 across all involuntary repossessions to cover these fees. Do you see that happening with all providers?
$200, I have not heard anything in that ballpark before. I mean, we do see increases, and again, we're seeing, I would say, more lenders opting to just increase the repossession fee by a modest amount than dealing with a case-by-case pass-through. But no, nothing in that range. I would say if you need a new provider, please call me afterwards.
All right, the next question is from Candace H. Is this only based on personal property fees, or does this also reflect on redemption fees that agents charge?
What a great question. I didn't even plant it. Well, and this is the last issue that I wanted to speak to today. Redemption fees are not specifically addressed in the consent order, but we have certainly been encouraging our clients to think about that issue as they decide how to handle the personal property matter. And just for clarity, when we refer to redemption, we're talking about a situation where the customer has had their car repossessed and they make arrangements with the lender, bring their account current, or make, you know, necessary payments to get the car back. And then there's an administrative process that takes place that the agent has to coordinate to release the car back to the customer. You know, and again, there's cost involved. They had to store the car on their lot potentially for several days. There's insurance cost and you know, sort of damage claim exposure on that. There's personnel that's required to handle it. So there are costs involved, and generally agents have been compensated for those costs in the past. And generally the transaction that occurred was between the customer and the agent. So the administrative fees, the storage fees that were involved, the agent in many cases collected those directly. So it's the same dynamic as we're talking about for personal property, but it is an issue that is technically not addressed under the consent order. But again, our recommendation is address them together and come up with something that that is consistent between the two. And a number of lenders have done exactly that. They've applied sort of the options that I reviewed earlier with regard to personal property, either increase the repossession fee or pass through. They've applied those same strategies and policies to administrative costs relating to redemption as well, but not required under the consent order. Bill, I don't know if you have anything to add to that. But.
No, nothing else to add there. I think that's right.
All right, the next question is from Renee K. Do you recommend agent billing a separate bill labeled personal property inventory fee if they redeem property to lender? Yes.
Well, again, our recommendation is streamline it by paying a higher repossession fee. But if it's going to be built separately and passed back through to the lender and stored and added to the customer's account, we don't see any problem with labeling the invoice or characterizing the invoice as a personal property handling charge. That's what it is. Again, and the CFPB's guidance last year would seem to suggest that that's okay, but if increasing the rate per repo addresses any concerns about adding these subsequent charges to the account, because it's just dealt with up front in that one charge.
All right, the next question.
There, Bill?
No, nothing else to add right there.
Okay. Sorry, Thee, go ahead.
The next question is from Mike K. He's curious which requirement is more important, not holding versus not charging direct.
Let you handle that one, Bill.
Well, I think they are sort of tied together, but I think it was more so the tactic of holding the property ransom unless and until the fee was paid that the CFPB definitely was looking down upon. As mentioned earlier on that one slide we had about with the supervisory highlights, the CFPB said, the examiners observed circumstances where the tactic of leveraging the personal situations for a collection was extreme. So if I had to pick one or the other, I would pick the holding property ransom, so to speak. That's how I'd answer that.
We have time for a couple more, Thee. Do you have any?
Yeah, so we've got a few more. This question is from Renee K. Can you have the agent charge a flat storage fee of, say, $50 if they don't charge storage to account for the property, and they can collect that there?
Read that one more time.
Sure. Can you have the agent charge a flat storage fee of $50 if they don't charge storage to account for the property, and they can collect that there?
I'm not sure I fully understand the question, but it sounds like can we bill it and call it something else? If there's some sensitivity internally to calling it a personal property fee, you know, our recommendation, because we don't believe that these fees are prohibited. Our recommendation would be just to bill it and call it what it is.
Right. You probably don't want to call it something that it's not. So that could get you into trouble. So yeah, I would lean towards describing it for what it is as well.
Okay, next.
All right, next question is from Troya H. If the member does not want to redeem their vehicle, but they had personal property, would we, the lender, still need to cover the personal property cost?
Well, those are two somewhat separate issues in our experience. So if they didn't want to redeem their vehicle, but they wanted their personal property back, then yes, there would be, I mean, there would presumably be a charge for that. Now, there could be, you know, in many circumstances, you have both redemption-related costs and personal property handling costs, but you can also have one without the other as well.
All right, next question is from Doug S. Would a generic rise in the repo fee to cover the cost of handling and releasing property increase the liability of an incorrect deficiency and possibly a countersuit on the deficiency if the unit had no property?
It sounds kind of similar to that previous question we had to me, Mike, about the propriety of raising the fee in light of the fact that there are times when you know, the service isn't performed per se for that, you know, for that increase. I don't know if there's anything new to add there in addition to what we previously had said. If you had any further thoughts on that.
You know, I'm not a lawyer, and you know, I'm sure that there are some legal minds out there that maybe view it differently, but you know, a repossession fee that covers a range of different services would not seem to be something that, and some of those services applying to some repossessions and not others would not seem to be something that would be very material. I can tell you that the concept of all-in-one pricing has been around for a few years now, where, you know, some lenders have set a repossession fee that not only covers the issues that we've talked about, but covers a variety of other possible costs that come into some repossessions and not others. I mean, we've seen some lenders that have taken it to the extreme where it includes not only personal property and redemption handling, but mileage, excess mileage fees, flatbed fees, storage fees. In one case, includes transport fees. And these are big institutions that have adopted some of these policies, and so I think that this particular question is probably something that they looked at and determined that there wasn't meaningful risk. But of course, would advise any lender to, you know, to seek counsel on it.
All right.
Maybe one last question, T.
Yep, we've got another question from Litzy O. Is having the agent not charge the personal property fee national, or does it differ per state?
Well, I think that as it relates to the CFPB order, and certainly as it relates to Nissan, it's a national mandate. But the ability to charge, or any rules around what an agent can charge, you know, that is part of many state regulations. And most states, the vast majority, with just a very few exceptions, do allow agents to charge fees. Some states actually provide specific guidance on how much those fees can be. Other states categorize it as fair and reasonable. But any specificity around the amount of these fees is done at the state level. Anything to add there, Phil?
Yeah, I mean, to the extent the question is you know, the prohibition in the consent order, that would be something that, with regards to, of course, Nissan, applies nationally, and the things therein are sort of a more on a more nationwide basis. It's not specific to this. The consent order is not specific to a particular state. But again, as we pointed out, state laws do allow for, and as he just pointed out, for such fees.
Okay, well, we're getting close to 10 minutes past the allotted time. If you had a question and you didn't, and we weren't able to get to it, please don't hesitate to reach out to Bill or I. Everybody will be getting an email after the event today, and that'll have our contact information in it. You know, so we hope you found this information to be informative, to be helpful. Thank you very much for participating. Special thanks to you, Bill.
Thank you.
You know, we do these webinars about once a quarter, so you know, keep your eyes open. We try to pick very timely topics. Last point I'll make, obviously your feedback is really critical to the success of these programs. So we want to make them better each time that we do them. And the only way that happens is if we get your feedback. So as I said, this afternoon you'll get an email that'll have the deck attached, or a link to the deck that you can download, as well as a very short, less than 1 minute survey. So we'd really appreciate you giving us your feedback while it's still fresh in your mind. Again, thank you very much for your participation today, and we look forward to you participating again in the future.